Hello everyone! We will now discuss the fourth category of the SCG Codes of Conduct. With regards to transactions, this category can be divided into 4 articles consist of 9. SCG's Transactions, 10. Doing business abroad and international trading, 11. Business competition, and 12. Anti-laundering measures. Let's first start with Article 9, SCG's Transactions, which can be further classified into transactions between company in SCG and transactions between SCG and external parties. Conducting business transactions between SCG groups of companies must take into consideration the related laws and regulations issued by government agencies, SCG's regulations and authority, as well as the rules and conditions as set forth in each locality, with the detailed guidelines as follows. Let's take a look at a case study. If Company A wants to buy a motor scraps from the Company B, which is also an affiliate of SCG, in order to use it to train its technicians, Company B will not charge for the items since both companies are affiliates of SCG. Is this permissible? In this case, it is not permissible, as charges will have to be imposed according to market or book value, though the transactions are made within SCG groups of companies. Next is the issue regarding transactions between SCG and external parties, which must be conducted in accordance with the rules and procedures established by the law, government-issued regulations, and SCG stated policies, including obtaining approval according to SCG's strict operational authority. Additionally, the agreed terms and conditions must be adhered to in a straightforward, transparent, and verifiable manner. By avoiding transactions that may cause issues or damage to SCG or external parties, including promoting and supporting suppliers or business partners to comply with the SCG Business Partner Codes of Conduct and use it as a standard for conducting business together, with the detailed guidelines as follows. Let's take a look at a case study. If we are interested in purchasing products from SCG's business partners, can we make the purchase in the name of SCG to get a discount? In this case, it is not acceptable to refer to SCG's name for the transactions, as it may cause a misunderstanding that the transaction was made on behalf of SCG. However, it is acceptable if SCG also makes additional provisions for employees to purchase products for their personal use. Let us now continue to Article 10, Doing Business Abroad and International Trading, which can be classified into 2 topics as follows: doing business abroad and international trading. Let's first start off with doing business abroad. Currently, SCG's business operations also covers overseas. In doing business abroad, SCG must fully comply with the laws of the trading country in which SCG operates, including complying with the operational governance policy and relevant regulations, as well as refusing to take any actions that may be considered risky to being an offense under local laws and involved in any unclear or unregulated actions which may conflict with the existing laws, customs, traditions, or cultures. Monitoring on changes in the local law or regulations should also be made on a regular basis where the business is conducted, along with evaluating risk and impacts from the various changes in order to develop a prudent and appropriate risk management plan. Let's take a look at a case study. If there is an officer offering to help coordinate the issuance of the license to establish a factory in a foreign country without having to go through the usual procedures, will this be permissible? In this case, It is recommended that such assistance be denied and that correct legal regulations should be followed. The incident should also be immediately reported to the supervisors to find the right way in moving forward. Next, let's move on to the topic of international trading. By importing or exporting goods, or any transactions that are related to foreign countries, SCG must strictly comply with the relevant laws, such as import and export laws, custom laws, product safety laws, consumer protection laws, including SCG's regulation and guidelines that are closely related. Let's take a look at a case study. If a customer requests for documents that are inconsistent with the transactions that were agreed upon in the contract in order to receive tax benefits, would this be permissible? In this case, we should reject the customer's request and provide an explanation, while at the same time perform according to the agreed upon transaction. The supervisor should also be immediately notified in order to find the appropriate measures to move forward. Let us now move on to the Article 11, Business Competition. In this regard, SCG is committed to conducting its business operations by taking into account the ethics of trading with customers and business partners, and will not be involved in any actions that may result in unfair trade and obstructing free competition. In the event that SCG has a market dominance that is in accordance with the law, it will not impose unfair dominance of the market that may limit competitions or distort market forces, and will not agree to nor exchange business information with its competitors or third party that may result in the suspension, reduction, or the limiting of competition between SCG and its competitors. Mergers and acquisitions, whether domestic or foreign, must be conducted in a proper manner according to the conditions and procedures as stipulated by the relevant trade competition laws. A full understanding must also be established with full compliance with the law, rules, policies, and practices that are related to SCG's trade competition. In case of any doubts, SCG's legal counsel should be consulted from the beginning. Let's take a look at a case study. If invited by competing companies to attend seminars to exchange ideas about marketing plans, should we accept the invitation? In this case, it is advisable to decline the invitation and confirm that it is SCG's policy that prohibits the exchange of opinion on marketing plans or sales territories to mitigate price cutting. And now, we have come to Article 12 of the SCG Codes of Conduct, which is Anti-Laundering Measures. SCG strictly adheres to the rules and laws related to the prevention of money laundering and not be involved in accepting fund transfers, converting assets, or support the acceptance of fund transfer or converting assets that are involved in the commission of an offense. This policy is in order to prevent anyone from using SCG as a channel or tool to transfer, conceal, or disguise the source of illegally acquired assets. Let's now take a look at a case study. If a debtor receives payments from someone other than the contractual counterparty, is it acceptable to receive the payment? In this case, employees are discouraged from accepting funds from people who are not our contractual counterparts. However, if it is really necessary, the source of the fund should be verified first, including checking the relationship between the debtor and the transferor, as well as their background history.